Over to you, sir.
Very good afternoon to all those who have attended this session today. But very surprising that not many people have responded when the panelist had asked you that what is your expectations from this session today. Why we should understand what is the structure of the GST and GST tribunal is very important at this point of time, because a lot of litigation at the second level that we do not have any kind of a redressal, but for going in for a writ before the High Court. And as you know, that recently the Supreme Court has given a clear verdict saying that the High Court cannot entertain a writ when an normal appellate mechanism is already available under the law. They never said that whether it is available under the practically or not, but they certainly have told that under the law, the conditions should be fulfilled for the High Court to exercise its extraordinary jurisdiction. So keeping that in mind, tribunal's formation is an urgent need. So what is exactly the GST tribunal and how it is going to be functioned? Because very recently that we have got the procedures announced by the CBIC just to keep the momentum. So we need to understand what are going to be the nuances in the GST tribunal and how we have to file our appeals and how it is going to be heard and how we are going to receive the orders and the things like that. This is going to be general overall on that GST tribunal's procedures that I will be discussing in this session. The agenda will be the general overview. What are the events that have happened in the past to come with this legal framework now, and what are the critical issues that we are having, and then I will be open for the Q&A. Q&A can be any questions, but there is a separate Q&A box on the web chat. So there, that please pose your questions so that I can take it up at the end of the session. And all those who want to have any words and all that we can discuss in the end. So kindly bear with me. So next slide, please. See, the Goods and Services Tax Appellate Tribunal has been constituted by the Government of India under Section 109 of the CGST Act to hear appeals against the orders passed by the appellate or revisional authorities under Sections 107 and 108 of the said Act. So how the tribunal got constituted and what is the legality behind it is what is captured here. So the GSTAT has also been empowered to adjudicate or examine cases of anti-profiteering under Section 171 of the Act. So you know it that the anti-profiteering clause, everybody was expecting that it will have a sunset, but now that it has been extended for further period. So this anti-profiteering, if there are any cases and all, those are also going to be under the purview of the GST tribunal only. The GSTAT, being a national tribunal, has its principal bench at New Delhi and 31 other state benches located in the states and union territories, and will have sittings in 44 different locations across the country. So what are the significance of this? This national tribunal is going to be having a principal bench, which is going to be there in Delhi. They are going to hear only the cases where the dispute is about the place of supply. Otherwise, the principal bench will not be taking up any cases, but only when the case is involving principal place of supply, then the principal bench is going to be involved. Otherwise, all the states, all 31 states are going to have their own respective tribunals. Of course, in some of the states, because of the number of SSCs being more or the jurisdiction being vast, that they have set up more than one bench. Hence, there are going to be 44 different locations in which, in these 31 states, where the tribunal is going to sit. The tribunal is headed by a president who is to be a judge of Supreme Court or a past or present Chief Justice of a High Court. Besides the president, the principal bench has 3 other members, 1 judicial and 2 technical members, 1 from the center and another from the state. All other benches have 4 members each, 2 judicial members and 2 technical members, 1 from the center and 1 from the state. That's how the tribunal's constitution is going to be. So once it is clear why we are going to have two members from the technical, CGST and SGST. So in order to deal with the CGST and SGST, we are having 2 technical members. So in order to have a division bench with a technical member and a judicial member, they are going to have two judicial members. So one judicial member with CGST and another judicial member with SGST will form two division benches in all the locations. So that's how the benches are going to be constituted. The cases will be heard single member or the division bench also. But when a division bench is having is not able to conclude on a case, then in such a case, the matter will be referred to the president for constitution of a larger bench. It's not going to be a larger bench for reference to a third member. So that's what it is going to be. So that and all that we are going to take it in the other slides. But constitution of the members principally is to balance it. Equal number of technical, equal number of judicial members are going to be there in any bench or in the sitting also. Next slide, please. While the judicial members are drawn from the judiciary and are from the legal profession, the technical members are drawn from the pool of senior tax or revenue officers from the central or state governments. GSTAT is the highest court in the country on matters of fact in any litigation on GST. So, two important things here. The judicial members are going to be drawn from the judiciary or from the legal profession. This word "or from the legal profession" has got its own litigation behind. Madras Bar Association has fought for this, and then only the members from the legal profession were also allowed to be the judicial members. Otherwise, that initially when the government has formulated, they did not allow the legal professionals to be the judicial members. However, because of their agitation, that this could be possible. And the second thing is GSTAT is the highest court in the country on matters of fact in any litigation on GST. So people may be wondering that Supreme Court is the highest court in the country. So why you say that GSTAT is the highest court? GSTAT is the highest court in the country on matters of fact. On matters of law, Supreme Court is the highest authority. So we need to be very clear that when it is a matter of fact, then what GST tribunal is going to decide is going to be the final say. And even if the matter is going to be further agitated in the high courts and the Supreme Courts, they will not be going into the facts. They will be dealing only with the point of law. Hence, we need to keep it in mind that when our litigation is on matter of fact, the highest body is going to be GSTAT, and after that, nobody is going to bother about the facts. It is all going to be law. All appeals before GSTAT are to be filed only in electronic form and manner with facility for document upload. Of course, again, this statement has got its own controversies. You might have seen in the newspapers when the procedures was announced, because that they have used some controversial wording while drafting the procedures, which we will be discussing in the coming slides. Appeals and applications once filed on the e-filing portal of the GSTAT are processed through help of the case information system and document management system, and all orders are also passed and uploaded on the website of the GSTAT, which is also the first tribunal in the country to go digital from its very inception. So this is the first ever tribunal constituted in India, which is going to be functional, and it is going to be completely in a digital mode only. Hopefully that they are not going to ask for any manual filing. But yeah, as I told you, that some controversy in the drafting, which we will be touching upon. But otherwise, it is going to be the first ever tribunal, which is completely digital right from its inception. All concerned stakeholders in the GST litigation will be able to get a live update of developments in their cases. Hearings of the GSTAT will be in hybrid mode, affording the facility to opt for a physical hearing to attend it electronically from any remote location. So this is a discretionary. It's not mandatory that they are going to give you only offline hearing, sometimes online hearing. So this is a hybrid mode. So it will be decided on case-to-case basis on the bench. Next slide, please. So tribunals are quasi-judicial institutions set up for fast, inexpensive, decentralized adjudication of the disputes in various dispute matters, such as administrative disputes and tax disputes. The original constitution did not contain provisions with respect to the tribunals, but 42nd Amendment Act of 1976 added the new part to the constitution, which contains only two articles, 323A dealing with administrative tribunals, 323B dealing with the tribunals for other matters. So our GST tribunal falls under 323B, Article 323B of the Constitution. The tribunals and courts both deal with the disputes between the parties which affect the rights of the subjects, but there exists some difference between the two. So what are the differences? In a court, it is part of the traditional judicial system, but a tribunal is a quasi-judicial body. So we have to keep very clear that what is judiciary and what is quasi-judicial body. The civil courts have judicial power to try all suits of civil nature unless cognizance is expressly or impliedly barred. Tribunals have the power to try cases of special matter which are conferred on them by statutes. So, a tribunal, when it is constituted, it will be told that what all matters come under its purview. Now, in a GST tribunal, that is the reason that they have very specifically told this tribunal is constituted for taking up the disputes in GST. Also, that they have mentioned that it is also going to deal with anti-profiteering matters arising in the GST. So, beyond that, they cannot handle any other matters. Like the CBDT Direct Tax Tribunal is having some members are not there. Hence, whether those matters can be dealt here, no. Similarly, any administrative tribunals matters cannot be dealt here. So, any tribunal, when it gets constituted, that they will very specifically point out on what subjects the tribunal can deal with. So, that has to be kept in mind. The judiciary is independent of the executive. The administrative tribunal is entirely in the hands of the executive. And in a court, it is bound by all rules of evidence and procedure. But in a tribunal, it is bound by the principles of natural justice. So this is the fundamental difference between a court and the tribunal. See, in a court, it is the rule of evidence and the procedures. So they have to follow only that. But in a tribunal, it is principles of natural justice. What are the principles of natural justice? That you should give an opportunity for both the parties to express their views. And after that, the order should be a judicious order, wherein that it is a speaking order that you have to bring out all the facts and all the facts put out by both the rivaling parties and how the decision has come and how you are the deciding authority is negating the points put forth by either by the appellant or by the respondent. So it should be a speaking order. So unless these are observed, then the principles of natural justice are not complied with, and then that such an order will be held as ultra vires. So the next slide, please. Yeah, I think there is a poll by Pawan.
It's a poll time, guys. I'll be launching a quick poll related to the things that we have just discussed. The poll is on your screens. Which of the following is not a power of GSTAT? Summoning individuals, issuing commissions for witness examination, granting criminal bail, receiving evidence of evidence. Please type your answers in the poll box, guys. You can see good number of responses already. Also, guys, we'll be having a dedicated Q&A session at the end of the webinar. So be prepared for asking more and more questions, and you can use the Q&A box that is provided in the Zoom so that we will be picking up your questions from start. I'll be ending the poll in another 2 seconds. Sir, any opinion on this, sir?
Yeah. So majority of the participants have correctly answered it. Granting criminal bail is not one of the functions of the GSTAT tribunal. So the tribunal can summon the individuals. They can issue the commission for the witness examination. They can receive evidence on affidavits and all that. But what they cannot do is granting a criminal bail. That's not possible. Yeah.
Thank you, sir.
So, GST Appellate Tribunal composition includes a national bench situated in New Delhi, constituting the president, a judicial member, and technical members, one from the state and another from the center. So, this itself is going to be a debatable issue that from the center CBIC that there can be a person, but from the state there should be a person. So, which state will have their representative in the principal bench will be a big debate. But that's how the constitution is, that we can't help it. Maybe that they will offer this on rotation, or what is going to be the procedure, that we need to wait and see. Further, there are 31 state benches consisting of 2 judicial members, a technical member of center and a technical member of the state, which I told you, but the sittings are going to happen at 44 different locations. Because some states, there will be more than one bench. The tribunal is not bound by the Code of Civil Procedure, but follows the principles of natural justice and has authority to regulate its own procedure. The tribunal possesses powers similar to a civil court under the CPC for matters such as summoning individuals, demanding document production, and receiving evidence or affidavits. The tribunal can requisition public records, issue commission for witness examination, and dismiss or decide representations as the default. And orders issued by the tribunal can be enforced as if they were court decrees, with the tribunal having the authority to seek execution within the local jurisdiction. All proceedings before the tribunal are considered judicial proceedings, and tribunal is deemed a civil court for specific legal purposes, aligning with sections 193, 228, 196 of the relevant legal codes. So, the tribunal is completely empowered under the law, and is a kind of a constitutional body, you can say. Next slide, please. So now we go to the history, like what are the things that have happened in the past, which have culminated in what the procedures that currently were notified. See, the Income Tax Appellate Tribunal started functioning from 25th January 1941, but the Indirect Taxes Tribunal started functioning from 11th October 1982. Central Excise and Salt Act 1944, when the CESA Act was made, but the tribunal took its own time to get constituted for indirect taxes. So, in the GST, everybody is worried that on 1st of July 2017, when the GST was promulgated, that why the tribunal is taking so much of a time. If you go into the history, you will appreciate that I think in 8-9 years, if you are able to see the tribunal, that itself is a wondrous achievement. Because in the earlier Central Excise regime, that the Central Excise Act was enacted in 1944, whereas the tribunal has commenced its operations in 1982. So we are very quick in constituting the GST tribunal. So nobody needs to criticize the government that why there is so much of a delay. Yes, it is causing some heartburn, no doubt about it. But the thing is that it will take its own time. On the basis of the recommendation made in the 32nd GST Council meeting on January 10th, 2019, the central government-wide notification 1359 dated March 13, 2019, notified the creation of National Bench of GSTAT with effect from the date of publication. However, the provisions of 109 and 110 of the CGST Act relating to the constitution of the Appellate Tribunal and the appointment of the president and members of the Appellate Tribunal qualifications, related conditions of services were challenged before the Honorable Madras High Court in the case of Revenue Bar Association versus Union of India, which I was referring to, because initially they thought that the judicial members can be from the tribe of judges only. So the advocates cannot become judicial members. So that is what was challenged in this particular decision, where it was recommended that amendment should be introduced to include lawyers as eligible persons for appointment as judicial members, which was further challenged in the Honorable Supreme Court. Pursuant to the aforesaid judgment and on the basis of recommendations made in the 49th GST Council meeting on 18th February 2023, amendments introduced in 109 and 110 by way of Finance Act 2023 with effect from August 1st, 2023, wherein the number of judicial members in the state bench was increased and the lawyers were also included as an eligible person for appointment as judicial members. So this is what is the importance, that after the Supreme Court's decision in the Madras Bar Association's plea, then the amendments were made. The central government, on the recommendations of the GST Council, has constituted the state benches of GSTAT at various locations as per notification bearing that number on 14th September 2023. Next slide, please. So they made the rules relating to the appointment and conditions of the president and members, appointments, conditions of services of president and members, rules 2023. How further, on the basis of recommendations made in the 49th GST Council, the central government, by way of a notification, approved the constitution of the principal bench of GSTAT at New Delhi. The Department of Revenue, by press release in 24, invited the applications for the post of various members of the GSTAT, that is CGST members. The appointment committee of the cabinet, based on the recommendations of the search cum selection committee, approved the appointment of Justice Retired Sanjay Kumar Mishra, former Chief Justice Jharkhand High Court, as the president of GSTAT, who is still functioning. With the appointment of the Honorable President of the GSTAT, the pressing issue in the present scenario would be the calculation of the time limit prescribed for filing appeal. The main problem is that appointment process of judicial and technical members has not yet started in full swing. The government notified the vacancy to fill up the posts of 63 judicial members and 32 technical members in the principal bench, which is still pending. So these are the things that have happened in the past. Next slide, please. So the CBSE wide Central Goods and Service Tax removal of difficulties order in 2019, read with Circular 132, which is issued in 2020, was issued, wherein clarification was provided that appeal before the GSTAT should be filed within 3 months or 6 months in the case of government, and appeal from the date of communication of the order or from the date on which the president or state president of the appellate tribunal would assume office, whichever is earlier. Since the president has assumed the office, is the time limit over? That will be the biggest question. So the relevant portion of the aforesaid ROD and the circular have been reproduced here for reference. So the order says, for removal of difficulties, it is hereby clarified that for the purpose of calculating the 3 months from the date on which the order sought to be appealed against is communicated to the person preferring appeal in subsection 1 of section 112, the start of the 3 months period shall be considered to be later of the following: the date of communication of the order, date on which president or state president, as the case may be, of the appellate tribunal after its constitution under section 109 enters the office, there are 6 months from the date on which the said order has been passed. In subsection 3 of section 112, the start of the 6 months period shall be considered to be later of the following: date of communication or date on precedent. So this is how that they have extended the time limit. Even this removal of difficulty circular is also lapsed, because these time limits have also crossed by now, and still we do not have tribunal in place. Next slide, please. So the appellate tribunal has not yet been constituted in view of the order of the Madras High Court in the case of Revenue Bar Association. Therefore, appeal cannot be filed within 3 months from the date on which the order sought to be appealed against is communicated. So in order to remove the difficulty arising in giving effect to the above provisions of the Act, the government, on the recommendations of the council, has issued CGST removal of difficulties order. It has been provided through the said order that the appeal to the tribunal can be made within 3 months from the date of tribunal communication of the order, or date on which the president or state president, as the case may be, of the appellate tribunal enters the office, whichever is later. And the 3 months time limit for filing appeal by taxpayers to GSTAT has already been started from May 6, 2024. So there is a pressing need for the GST Council to issue a special order in this regard for extending the time limit for filing appeals by taxpayers to GSTAT, because of the appointment process of the judicial and technical members has not yet been started in full swing, in light of the vacancy notified by the government to fill up the posts of 63 judicial members and 32 technical members in the principal bench. So this is where that the controversy is still waiting. But because the tribunals have not yet started functioning, maybe the government did not come out with any further instructions. So we need to wait. Next slide, please. Yeah, another poll for you.
There is another poll for you guys. There is a poll running in our LinkedIn page. I'll just paste the link in the chat box. The link is in the chat box. If you click the link from the chat, you will be directed to the poll directly. Click the link in the chat box and you will be directed to the poll that is happening in our LinkedIn page. What happens if you miss the 3-month GSTAT appeal deadline? Penalty? Case dismissed? Needs condonation? No idea. Please put the answers in the poll, guys. Click the link in the chat box and you'll be directed to the poll directly to the LinkedIn page.
I am seeing the participants are slowly leaving. Maybe it is not a very much interesting topic for them, though there are a huge number of registrations. Because many people are thinking that why to go to tribunal when the matter can be settled at the lower levels, which is always a good idea, but nothing is in our hands. So when you have to knock the doors of the tribunal, you need to be thorough with the procedures. Pawan, the time for the poll is over.
Yes, sir. Over to you.
Yeah. So what is the legal framework? Let us see that it is notified under section 111 of the CGST Act. Effective date is 24th April 2025. It lays down the digital first, transparent and standardized dispute resolution mechanism to operationalize the GSTAT. Next slide, please. So what are the key features of the GSTAT rules? It is an electronic filing. Appeals are to be filed through GSTAT portal. So you can refer to Rule 18.115. Deposit requirement, 10% of the disputed tax amount must be deposited, maximum 20 crores per CGST and 20 crores for SGST. Of course, if it is a second appeal, no brainer it is, further 10%. And the structure will be principal and state benches with judicial and technical members. Authorized representative requires to file the proper authority document. Time computation, holidays excluded, delay is condonable. Hearings generally public, ex parte decisions possible. Cause lists are going to be published daily online. Additional evidence is allowed only with tribunal's approval, and registry is managed by the registrar. Scrutiny and records, everything is maintained by the registrar. Next slide, please. So summons and enforce attendance is the powers as per the CPC. Of course, now that the name has been changed, inherent powers to prevent abuse of process and to meet ends of justice. And error rectification is also possible under Rule 26 and 108. Higher court orders, they are to be informed to the tribunal for complaints, if any, and recusal of the members, they can recuse themselves without disclosing the reasons also. We are very frequently seeing in the newspapers that some judge recuses himself from hearing the matter. It can be because earlier, when he was practicing as an advocate, he might have guided the client, or he might have appeared for the client in the same matter in some forum. Hence, he cannot be the judge in the case. In such a scenario, he can recuse. If some relative comes for him as a representative or as a appellant or the respondent, in such cases also, the judges recuse themselves. So, such recusal power is there. Next slide, please. Yeah, I think, procedure and administrative aspects, 5,000 rupees for inspection application, 5 rupees per page for certified copies. Operating hours, tribunal is going to sit between 10:30 to 1:30 and 2:30 to 4:30, but office hours are 9:30 to 6. Central government notified locations, they are yet to be notified. We have to wait and see. Next slide, please. So appointments, judicial and technical members being appointed, and the GST network has to build the platform for filing and processing of the appeals. There is a portal, but you can't file any. The digital divide, small taxpayers may face access issue. transition, immediate preparation is advised for drafting appeals and gathering the documents, because once the portal is open, immediately you have to push for it because the time is very small. Next slide, please. So how the legal framework is that the sections are like this. What are the preliminary powers and functions, institution of appeals, cause list hearing, record of the proceedings, maintenance of registers, inspection of records, appearance of the authorized representative, affidavits, and then discovery, production, return of documents, examination of witnesses and issue of commissions, disposal of cases and pronouncement of orders, electronic filing and processing of appeals, and conduct of proceedings in the appellate tribunal in hybrid mode. Miscellaneous. That's how the chapters are divided, that if somebody is interested, they may go through all these details. Next slide, please. So what are the various forms that you should be familiar with? There is a form for interlocutory application to the appellate tribunal, IA deals call, then order sheet, format of indexing, then application to the registrar for inspection of records, memorandum of appearance, before the GST tribunal, that summons are also there, and then certificate of discharge, cause list, court diary, register for provisional appeals, register of appeals, register for IAs, register of inspections, Supreme Court and High Court orders. So all these, there is a specific format in which it has to be. So one should be familiar with these forms while dealing with the GST tribunal procedures. Next slide, please. So an appeal to the appellate tribunal shall be filed online on the GSTAT portal in the prescribed form under rules and shall contain the following. It should have a cause title, shall state in the Goods and Service Tax Appellate Tribunal, must set out the proceedings or order of the authority being appealed. Structure of the appeal should be, it should be divided into consecutive numbered paragraphs. Each paragraph shall contain as nearly as possible a separate fact, allegation, or a point. Full name of the party, parentage, GSTN, description, address of each party shall be provided at the beginning of the appeal. These details need not be repeated in subsequent proceedings of the same appeal. A numbering of the parties shall be numbered consecutively. Each party's name and description shall be on a separate line. If a party dies during the appeal, their legal heirs or representation shall be shown as the sub numbers. Next slide, please. So conditions to be met for being under the compositions. Sorry, I think this is a wrong slide which was brought in, Pawan. Next. Yeah, what are the critical issues? So an appeal to the appellate tribunal shall be filed online on the GSTAT portal is what Rule 18.1 says. But Rule 19 says the registrar or authorized officer shall endorse on every form of appeal the date on which it is presented or deemed to have been presented under that rule, and shall sign the endorsement if the appeal is filed manually. So if it is filed manually, then he may have to sign. But if it is filed online, how he is going to endorse each and every form of the appeal? That is a big question. Further, Rule 112 says all orders shall be neatly and fairly typewritten in double space on one side and only on durable full-scale folio paper metric A4 size with a left margin of 5 centimeters and right margin of 2.5 centimeters. So when you are specifying what should be the physical document that requires to be used for filing an appeal, is it that it is going to be a manual process or it is an online process? Because if it is an online process, nobody needs to tell you on what page that it should be. But unfortunately, these rules, the way they were drafted, is leading to little confusion. So unless the tribunal starts functioning, that we will not be able to get any clarity. In the meanwhile, if the government takes cognizance of all these criticism, then they must come out with some kind of clarifications for us. Next slide, please. So what is the time limit? 3 months it has to be. A delay can be condoned for an additional 3 months upon showing sufficient cause. Cross objections can be filed within 45 days of receiving the notice with similar condonation provisions. Next slide, please. So these are the important things. That's all about the tribunal and how it can be filed. Because rest of the matters, what should be the dress code for the members, what is the dress code for the respondents, and how you have to file an IA, all these aspects, those are all final things which are not being dealt here. I think that from my end, whatever the procedures that were announced that I have summarized for the benefit of all of you. And I have given the relevant notifications and the rules and sections also. So if somebody is really interested, maybe that they can take this PPT and then they can go through the relevant provisions and all for better clarity. But in case if you got any kind of a doubts on this issue, that you are most welcome with your questions, which I can answer, not only on the topic that we have discussed today, on any topics under indirect taxes. The floor is open now. So you can type your Q&A in the Q&A box, your questions, or otherwise if somebody is interested, maybe that Pawan will allow them to directly talk with me so that you can explain.
Please type your questions in the chat box, guys, or else if you directly want to talk to sir, you can raise the hand, that the option is provided with you so that I can enable your mics. So meanwhile, we have some questions from the registrants when they registered.
Are they registered for queries by the registrants are available now?
That I'm not sure, sir, but it may benefit to the people.
Yeah, no problem. Go ahead.
As a mutual fund distributor, AUM below 1 CR, that case I enroll in GST, no purchase or billing my business.
What is the question that he has?
Okay, I think this is.
He told some facts, but he did not pose the query.
Yeah. Status of everyone is asking for status, sir. Status of case of levying GST on existing members, old flats, full area after redevelopment of residential building in Mumbai.
See, redevelopment that he has to tell me in what way that it is being addressed. So is it going to be how that agreement is, depending on that only we will be able to discuss the taxation of it. That is the reason I told you that if the queries are available now, maybe that we can get the facts from them. Because while writing in the space provided, maybe they are too short and were not able to explain properly.
Yes, so there is a question in the chat box.
Yeah, there is only one, and Pankasha wanted to ask some question. I'll answer the Krishna Mohan's query first. What if first appeal order passed through manually and not able to rectify, how online appeal can be filed in GSTAT? Very interesting question, sir. This has already been debated in one judgment very recently. If it is done manually, then the first appeal also has to be manual only. But I don't think that anybody will be doing that kind of a step now. The first appeal order is going to be passed manually. So every single order, the people are, the revenue authorities are very clear that they are uploading in the portal. So even now also that if you are finding it that only manual order has been issued and it is not uploaded in the portal, definitely you can raise this a point that it cannot be appealed against, hence it is going to be a problem. That nobody can deny your right, hence you can raise this question. Pankaj has raised this question of redevelopment, hence CGST appeal is already passed manually. Then you have to insist them to upload it in the portal, sir, because for that to file an appeal, that you will face a challenge. So you better quote that recent judgment which has come from one of the high courts, and then you can write a letter to them. Readily that I am unable to recollect the judgment. Otherwise, I would have shared with you. But if you can leave your contact details, maybe that I can offline share the details with you.
Okay, I'll share my email ID.
Yeah, please.
Thank you very much.
Thank you. Pankaj, that you can discuss. What is your query?
I should discuss now.
Yeah, please. Go ahead.
Yeah, this in redevelopment cases in most of the areas. Maybe I am specifically since I am residing in Mumbai.
Yeah.
Nowadays, builders are getting notices from the GST post possession after 2-3 years also. And members are asked to pay the taxes since their builders have received the notices. While in the DA also, though they may have mentioned all the taxes have to be borne by the developer, but still they have received the notices later on. So that's why confusion is there.
No, but
The thing
what
is,
for the notices are being issued?
on the existing, say now, when the society goes for redevelopment, the existing area, say it may be 500 square feet existing, and he may be offering some 25% more area
Correct,
in the new building.
correct.
So he is entitled for 500 plus 25%. So
Right.
say 625 square feet.
Right.
Earlier, the tax recovered from the developer was only on the 25%. I think they were supposed to pay the taxes. Now the department is asking for existing 500 square feet plus 25. So total 625 square foot area, they are asking to pay that GST on the full area.
Correct.
So that confusion is there, and the
Why there is a
notices are
confusion? There is absolutely no confusion, no, sir. See, this building was constructed long ago.
right.
So during that time, the service tax and VAT, central excise, all those tax laws were there. So as per that, whatever the taxes applicable at that point of a time, all those were paid. So
Right.
there is no dispute, there is no carry forward and all that, right?
Yes. Since
Now
it
it is
is
a
an
fresh, now it is a fresh
agree-
agreement wherein the society is giving it for development, wherein that the developer is going to demolish the whole thing and then he is going to reconstruct. So when he is reconstructing, when is the occupation happening? That will be the question, right? So whether he is going to give you the position with CC and OC, then the GST is not applicable because it is going to be treated as an immovable property. But if it is given prior to that, then it is going to be treated as a works contract, and whatever taxes are applicable, that will be applicable on the 620, 100 plus the 25 extra also. But it cannot be the case that for 100 that some time ago in the BC that the taxes were paid cannot be an argument, no. This is a
See, the query
transaction tax.
was since the existing members are not purchasing, they are just shifting temporarily and getting back the new area. They
But
are not purchasing. There is
no,
no
no.
agreement for the purchase of the existing plus entitled free
Correct, sir.
area. So
Correct. But
that
what I'm saying that if you are purchasing an immovable property, there is no GST on it. But when you are receiving some service from him, then the entire service is to be taxed. No, it cannot be the case that only the extra percentages will be taxed. A portion of it will be taxed.
so
They are
that they
receiving
are
the entire
already
service,
paying
right?
on the whatever construction cost is there, that they are already paying the GST on that for building whatever material and services, labor charges,
Who is
whatever
paying?
he is spending, that
Who is
builder is
paying?
already paying to the government.
Exactly. So, see, there are two different transactions. See, we are dealing with a transaction tax. So, each level, whether the taxes have suffered or not, is what you have to see. When the builder is constructing, when he is buying materials from the store, from the shops and all that, that is one transaction on which he is paying taxes. Okay, I agree. But when he is putting everything into the structure, then he can, if it is subject to the 17.5 regulations and all that, if it is not resulting in immovable property, all that and all, then he can avail the credit. But if it is resulting in an immovable property, he cannot avail the credit. But that transaction is over. As far as the tax payment by the builder to the shopkeeper for buying those materials, the transaction is complete. Whether the credit
Right.
is eligible or not is something which has
No,
to be
that is
evaluated under
that
17.5.
developer is paying GST on it, but the
The
GST
reason,
is
no,
being asked from the members who are staying
sir,
in the
I'm
old
coming to
area.
that. I'm
Yeah,
coming to
sorry,
that.
sorry.
When we are dealing with a tax, no, that you should not be having the background that the entire story falls into this. Hence, what is the tax? It cannot be the way. Each and every transaction that you have to examine. The first leg of transaction is the developer buying materials on which tax is paid. Whether the developer is entitled to credit or input credit or not is something which we have to examine separately. That is not the debate now. Now, the second leg of the transaction is developer is handing it over to the society and its members. On this leg, tax has to be paid, no? You cannot say that the developer has paid it. If developer is entitled, then he will take credit and subsequently he will again be charging you. So that credit can be utilized. But if he cannot avail the credit, then that is a separate transaction. The transaction got over, its taxation is over. This is a separate transaction between the developer and the society and its members. So that has to be taxed. You cannot
The
link these two and
No,
say,
the
since the
taxation
developer
is
has
on the
paid it.
full purchase area, as if he is purchasing, the member is purchasing whatever market area is going on.
Yeah.
Say 40,000, 50,000, whatever per square foot. On that, the tax is being asked, I believe.
This is something that unless we see the exact agreements, how the terms were worded, and what is going to be the taxable service and what is its valuation, that we can discuss. But primarily, what you need to understand is, if the developer has paid for the raw materials, the taxes on the raw materials, then he should not be charging to the members, is a wrong assumption. That I want to set it right first. Okay, because that is a separate transaction. This is a separate transaction. In order to examine whether there is going to be tax and what portion, whether it is going to be on the 500 SFT or 625 SFT, in your example, that can be decided only after reviewing the agreement.
Besides the agreement, the government is giving notices to the developer for tax on the full area as per the market rate. That is what is being given to understand.
This is all emanating out of the agreement. How the agreement is worded? What are the terms and conditions? What is the portion of the service that has been
The
agreed?
GST department is not seeing that agreement. They just are seeing that the full new house is being given to the member and they want revenue from it.
No, maybe some authorities might have given it because everybody in the market is giving, hence why not me? But that cannot be a correct notice, no? We
So
can challenge
that
the notice
confusion
also.
is there as such.
No, there
From
can be
the
confusion. I'm not saying no. But only thing is that we cannot say that every single officer is going to give the notice. Like nowadays that you are getting notices for reconciliations. God knows where from that they are getting the numbers, but they are asking you to explain. So if you go through your books, if those numbers are not matching, certainly that you can go before them and say that these are not my numbers, what you are releasing in the show cause notice. My numbers are like this. And now there is a reconciliation also that they are agreeing, isn't it? So there may be some drop of hat show cause notices, but not every authority is issuing like that. Definitely the basis for the show cause notice is going to be your agreement. If they have not seen the agreement, but despite of that also, if they are issuing a notice, your first line of defense can be that only. My agreement is on these terms, so I am liable for only the tax to this extent, not as you are thinking. That can be your defense. Right, sir? Yeah, I am taking up these two questions here. In case appeal filing time limit has passed, what we have to do, that we have already told, that you can seek condonation. But there should be, if condonation time is also lapsed, terminist policy, sir, we can't do anything. See, when the law gives you some time limit, then the law also gives you some time to delay or to condone, the power of condonation. If you have exceeded all of them, and if you are sleeping on this issue, then nobody can help you. Suddenly you wake up and say, no, I've got some right, hence please give me. It can't be the case. Because the litigation will never end in such a scenario. So the time limits are there. We need to be vigilant and we have to honor those time limits. And for all of you, that recently Chennai High Court has given a decision, Madras High Court has given a decision wherein they say that uploading the order in the, you will get the PPT. That's not a problem. I told you that. So the Chennai Madras High Court has given a decision that uploading the orders in the portal is also a effective delivery. So we have to be very careful. Don't ever think that I will get an order in the register post. If it is uploaded in the portal, that is good enough. Please, just now that somebody is saying that unfortunately his order was given manually only. So now that he is having a serious problem of how to file an online appeal. So that manual order has to be uploaded by the officer, or otherwise that we have to tell them how it has to be done. Otherwise, it is going to be a problem. So you have to monitor, and there are, I don't know whether Websol in the floTax that they have included this also, that maybe Pawan will throw light on it. that there is a litigation monitoring system. Wherever that you are getting any show cause notices, any orders are passed against you, immediately these guys are going to help you and keep you informed that so-and-so order got uploaded. Please check what is the action that you need to take. So that kind of a proactive systems are also available in the market. So please explore, because once it is becoming digital, life is going to be hell unless you are tech savvy. Any other
Sure,
question?
sir. I'll check with my team
Yeah,
whether
please.
the system is there or not, and I will inform to all the audience.
Yes.
Krishna Mohan, do you have any question? I have enabled your mic to talk. Mr. Krishna Mohanji, if you have any question, you can unmute yourself and you can talk.
See, I'm only interested in this one, this what you call this first appeal order, no, where it was passed manually. We tried
Yeah,
all.
which I have told you, sir, that
Yeah,
there is a judgment by the High Court also. You can quote that and you can request the officer to upload it, because that you should not be denied your opportunity of going in for an appeal.
in fact, what it has happened is when they have passed manually. When we try to rectify also, the system itself is saying already it has been passed manually. But though the DIN number or whatever that reference number is there generated, but on that they have mentioned as a passed order appeal passed through manually. Now, since this GStat is only offering for through online, no, then ultimately we will be losing our right, no.
No, that's why, sir. See, it is not your problem, right? It is their problem. How they
Is
are
it-
going to rectify is going to be for them. So you put it in writing, give it in a writing. That see, sir, that this is what is the problem. GStat is completely online, and since you have issued the order manually, which I have want to go in for an appeal, that kindly enable the system, that how your manual order can be appealed against. So please guide us. Or otherwise, as per the judgment of this High Court also, that you are supposed to upload it. Hence, you please do it. You can't say that there is a system constraint, because system has been designed by them only, not by you.
There's one more question, sir. Since GStat is based on facts and figures.
Yeah.
Now these officers are passing orders, even though, see, for example, in GSTR 2A, table 8A. So see, when that figure has come into our 2A, the table 8A, but we do not have that invoice, where neither we have not taken the credit. But they are simply that they have cancelled, they are under cancelled dealers, and you have to reverse that ITC. Even when we have replied also, in some of the 1 or 2 cases, they have rejected and passed an against order. But though it's a small value, say 1 lakh or 2 lakhs. So in that case, if this is the if it goes like this, can we get a benefit in that GStat on basis of facts?
Definitely. See, GStat can give you some kind of a solution. But the thing is that what is exactly the facts behind, and how it has to be represented is what is the case. Definitely, at a higher forums, that the orders will be more judicious.
Because anyway, first appeal also, I don't think they will give a positive order to us.
No,
Not
don't
only
have such a kind of a negative impression, sir, that there
no,
are
no,
some good
generally.
officers.
Maybe 1 or 2, but mostly it may not.
See, that is what is the PTV part of it.
No,
But definitely at some point of a time,
I will tell you the best example which I am saying this manually, no, sir. Actually, this was a Tran 1 issue order, where we have inadvertently omitted to report in the ST3 returns, but carried over in Tran 1 and taken the credit. But we have paid the challan along with interest, whatever it's there. Even though when we have paid, they have not disputed anything. Simply they say they have passed this order under section 74.
oh God, okay.
Even though I have produced all the challan proofs, payments, what exactly has happened and all, simply without even orally they have accepted, but while passing that order, simply they have rejected at the first level itself and second level itself.
No, it can happen, sir. That I'm not saying that you will get immediate justice. Otherwise, why to have a hierarchy? See, if the lower level, lowermost authority himself is a judicious person and he is going to give you the orders and all, you need not have an appellate commissioner and High Court and Supreme Court and tribunals and all this, no? So that problem is always there. But what I'm saying is that you have to, if you are correct on your facts, no, then certainly it is a good case to go for an appeal.
Even that case was approved by upheld by that the Gujarat High Court in case of that someone port trust is there, some port versus Union of India.
Okay.
some Deen Dayal Port Trust. Case law is clear. Even that case law also he has not referred while passing this order.
No, certainly on these points that you can certainly go for an appeal.
But only my concern is since they have passed this manually, I'm really every day I'm struggling. Those people are not able to rectify that. Even that
No. You give it in writing under acknowledgement that at least your protest should be there in writing.
I have given that even that grievance also I have mentioned given, sir, but they have mentioned that to contact that first appeal authority. They have given one name, so I need to contact her.
Yeah, but whatever you do, sir, please don't do it orally. That keep that record.
In writing only.
Yes. That record will help you.
Sir, this is one question out of this appeals. This thing, just I want to understand whether that table 8C figures are linked to table 8A and GSTR 9. This is only my question. One, can it be confirmed whether these that whatever the table 8C figures of GSTR 9?
That I have.
I think that you just that another person know that organizer who is organizer in his spare time. It is found. It is matching means what I observed is that same figure when they are giving the notices under 2A 3B mismatch note comparing the table 8A and 8C. I have observed that whatever is appearing in table 8A, that figures are also appearing in table 8C, that invoice value, which I feel that notice is getting a little bit exaggerated.
No. This is happening because I'll tell you, sir, what has happened that the department is using certain kind of analytics. So even manual intervention is not there. Even if some small digits are also appearing here and there also, that it is throwing up the notices. The officers themselves do not know that some notice has gone under his signature because the digital signature is being appended and the notices are being issued by the system only. So such kind of things can happen. But if your facts are correct, then you can always represent.
Because I observed this one, because whatever is appearing in 2A, then I put a link with that, whether it is appearing in 8C. I found most of the
can happen, sir. Can happen. That's what I'm telling. That if your facts are correct, then you have to represent it. That's it. Because some of them are system given notices, not by the persons. Of course, persons are also doing wrong. I don't say that they are right, but the manual intervention was not there. Even the officer doesn't know it. So if you give the reply, maybe that it gets closed.
And even if they are giving a notice also, they should first see the for 2A 3B and all. They should first go into start from table 6. Then only they have to come for. This is my opinion.
We can't dictate them what they are supposed to do, but there is a SOP for them which they may be they are supposed to follow. Whether they are following or not, I am nobody to comment, but that happens.
Okay, I think we are up to the time, sir.
Yeah.
Mr. Krishna Kumar, if you have any questions, you can reach out to me at pavan.sahu@websol.com. I'll provide you the details of sir. You can directly talk with the sir. Also, audience, I'll be sending you a presentation of this webinar and the recording. The live recording is recorded. I will provide you both the links and the solution that we are providing related to floTax, all the GST management in a single platform. And you will be receiving a survey form just after this webinar. If you want to discuss any other topic that you want, you can just type the topic so that our next webinar will be related to the same topic. We usually conduct webinars every month once. So the next topic can be decided depending on your choice. Thanks
for all the participants. Thanks for your participation.
Yes, thank you, sir.